So let me quickly tell you, I reviewed your motions last night, and I think we've got a couple of problems. One of it is that the notices of hearing tell people to go to the court number that is in the style of their pleading. It doesn't alert them that it's a remote hearing, and it doesn't comply with our central docket notice. If you go to our website for the civil courts of Travis County, you'll see that we have hearing notices that you can just pull down and use, one for in-person hearings and one for Zoom hearings. I also noticed that the motions don't comply with Rule 10 of the Texas Rules of Civil Procedure because the motion is required to state that the party has been notified in writing of his right to object to the motion and to state whether or not the party consents, and that information is not present. The rule also says that you can withdraw only upon written motion for good cause shown. And your statement in those motions is you have good cause, but you can't explain it because it's attorney-client privileged. And I think you're going to have to give a little more information than that. If your client is here and wants to go forward with the hearing, I'm happy to, but given the problems with the notice and with the motion, I'm inclined to pass those two hearings.
Your Honor, if I may, I understand that for Nathaniel Brooks, and I can, get all that in working order. For Serrano, the client and the defense both agreed, and I did upload that order I believe it was since the setting of the hearing and the initial motion. They both have signed the order, so it is now an agreed order. Would you be willing to sign that off, given that the order is now agreed?
Where did you
that to the
upload it?
box link.
Okay. Give me a second. Yes. If it's agreed, I don't have a problem. It's only the ones where we have these issues and they're not agreed.
Sure.
All right. And that is in Serrano, you said?
Yes, that would be in Serrano. It's in plaintiff's uploaded other materials, and it's settled order granting motion to withdrawals counsel.
All right. So you're telling me that the initials on both Mr. and Ms. Serrano are a signature for each of them?
Yes, that's the one that we've sent it to the email address we always use for them, and they signed it off after having a phone call with them.
All right. Yes, then I will sign that one.
Okay. And then as far as Nathaniel Brooks, you'd like us to basically, let's say, amend the motion, include a brief statement of good cause, as well as the fact that they've been notified that they have a right to object, and then let's say reformat the notice of hearing to use the standard form that Travis County uses.
Right. And let me just say that other issue is in Travis County, as I think the rules of civil procedure require, our local rules say you can only have a remote hearing if everybody agrees to have a remote hearing. So if we haven't heard from those people and they haven't agreed to the motion, then I would question whether they've agreed to the remote hearing. So you may need to do the hearing in person if you don't have agreement.
Okay, sounds good, Your Honor. I very much appreciate that.
All right. Thank you.
All right. Thank you. May I be excused?
Yes.
Thank you.
All right. So I have reviewed the plaintiff's motion to defer payment on sanctions order until a judgment is rendered that was filed by the plaintiff on February 6th, and the defendant's response to that filed also on February 6th, and then the plaintiff's reply that was filed yesterday. So are those the three pleadings that we're focused on today?
Yes, ma'am. Those would be the three, and we have requested default judgment in our response for failure to comply with court's orders.
Yes, I saw that. All right. Mr. Gonzalez, you may proceed.
Yes, Judge. If you review the motions, I don't want to be too repetitive, but you signed an order on January 8th granting sanctions against the plaintiff. The order is silent as to when payment on those sanctions is due. According to the Supreme Court in Braden v. Downey, when an order is silent, the default is that payment is deferred until a final rule judgment on the case, so that the plaintiff has an adequate remedy of appeal. So I cited the case and I uploaded the case to the other materials on the box. But that's basically what. So we're just asking for the order to be amended, or for the court to specify that payment on those sanctions is not due until the conclusion of the case.
All right.
Oh, Judge, and sorry, and we did file an affidavit by Mr. Lopez stating the preclusive effect that it would have if he would somehow have to come up with this money right now.
All right. Mr. Brazier.
Yes, ma'am. Judge, we, our main thing, it was to reimburse us for some of our costs. We're over $70,000 and trying to, what we have, determined to be a vexatious case based on all the discovery in the case. But we don't disagree with his court site that he's entitled to appeal the order. Our response is primarily focused on his failure to comply with the order.
All right. So, in other words, you're saying that the case that he cited, you were unable to find any authority to the contrary.
Yes, I think the Supreme Court, and generally in every order, Judge, everybody gets a right to appeal. I understand that. So if he disagrees with it, he can take that up on appeal. I don't have and he filed an affidavit where the plaintiff said he can't go forward, even though he has settled another case for policy limits, and you would think he would have the money to pay, but he claims he doesn't, so we're not going to get into a spat over that.
All right. On the other hand, you're asking that I dismiss the case as a sanction.
Yes, ma'am. So I can quickly walk the court through what's going on there. So if the court has our uploaded exhibits to BoxyBot, I can take the court through the specifics.
Hang on, let me open that.
Yes, ma'am. So we're gonna focus on what the court's order December 31, 2024 overruled the objections, and it's going to be 4 items. So it's interrogatory number 5, request for production 6, 19, and 20. So it's going to be easier maybe if the court has jotted those down. And we can go to quickly to D11 and scroll to, oops, it's not letting me open that. Well, I don't know why BoxyBot's not letting me. I just did launch it a little while ago.
Yeah, I can't get it to open either. And it does have a quirk that if you include unusual characters in the name, it sometimes won't.
I opened them all this morning, Judge.
Yeah.
Well, let's see.
Do you want me to try to open anything, Judge?
Sure.
They all opened this morning, so
I was trying to open D11. Let me just double check while we're here.
Are we on? Or I'm not on, but if I need to be on, let me know, Judge.
So do y'all want a record of this hearing?
We'd like a record, Judge.
Okay.
Defendant.
So would we?
I'm sorry?
I'm able to open D11 when I open it from my iPad. So sometimes Mr. Brasher, if you exit out of that folder and go back in
Let me
or
try.
refresh, then for some reason that may work. It's worked for me in the past. So,
Yes, ma'am. Let me try that.
and Mr. Gonzalez, while we're off the record, I just wanted to let you know I looked at your exhibits and your exhibit list appears to be correct, but your exhibits that were uploaded don't match the numbering of your exhibit list. Just for future reference to let your staff know that those need to be consistent. That would be helpful.
Yes, sorry about that. Thank you, Ms. Williamson.
Judge, I did get out and got back in, and that did refresh it, and I can now open it. So maybe that.
All right. Well, I'm going in for the internet. And that usually complicates it, but works. Hang on. All right. I have that one open now.
Okay, if we scroll down to interrogatory number 5. So just a quick background of a couple of facts that we keep in mind here while we're going through this. March 10, 2023, Mr. Lopez de Paz was in the subject accident for this case. May 2023, he was in a subsequent accident and engaged different counsel, similar names. The counsel for this case is Begum, and then the counsel for the May 2023 accident is Berman. So Begum and Berman. Berman's for the May 2023 accident. The court signed an order December 31, 2024, overruling plaintiff's objections to interrogatory number 5. So we've been almost 6 months now, and we look at interrogatory number 5. We still have the objection there, and I'll show the court while this is so this is a violation of the court's order. He was required to fully answer the interrogatory, and because we discovered this May 2023 accident through some insurance affidavit deposition on written questions that we obtained, it was not disclosed to us. So that's what all the motion to compel was. Thereafter, we discovered after the December 2024 order that there was another accident in which he claimed he had not been injured prior to this subsequent accident. So the court overruled this objection to number 5 back in December 2024, and here we sit still with this objection that we have previously argued was frivolous based on physician, patient, mental health, and all these other privileges when that's what he is claiming in the lawsuit, and so he cannot make those claims. So then he files a supplemental answer. So these are sort of odd answers. I guess he does a supplemental answer, and then he does a second supplemental answer. And this is the other accident which he was involved was May 2023.
Hang on, let me just stop you and say, I'm looking at D11, and it is plaintiff's third supplemental answer.
Yeah, yes, ma'am. So
it was filed, it looks like it was served on January 8th of this year.
Yes, ma'am.
Okay.
So still after the order, we have the objection, and I'm going to show the court while this is problematic for this case because we can't get our arms around the records and the injuries in this case as he continues to assert the objection even though it was overruled. So then we have this second supplemental answer that he claims to the best of his knowledge where he went to get treatment for this May 2023 collision. And then we have this third supplemental answer on the next page where he gives us an address for Momentum Spine and Joint. So we have this kind of iffy thing. I don't know if this is everyone. Maybe it is, maybe it isn't. So if we go back to the request, and this will all tie in a second. If we go to D10, which is his supplemental request for reduction after the court's overruling the objections for 6, 9, and 10. If we go to 6,
Hang on just a minute. Let
yes,
me get there.
D10.
All right. I'm at D10. And I take it you want to offer D10 and D11?
Yes, ma'am. I would like to offer all the exhibits. We attach them except for one exhibit to our response, and we would like to offer 1 through 12 into evidence.
All right. Mr. Gonzalez, any objection to defendants exhibits 1 through 12?
Let me just go back to the uploaded exhibits for defendant, Judge. No objection, Judge.
All right. Defendants exhibits 1 through 12 are admitted. So you were talking about 10.
Yes, ma'am. So page 10, exhibit 10, page 4, this objection was overruled back in December 2024. And
you're talking about to request for production number 6.
Yes, ma'am. Request for production number 6. And so the objection continues to get lodged. And so here we're trying to get our arms around who are all the providers, who are all the medical records. No, we don't want any surprises. We want to know all the injuries because previously we were not told about them. So, of course, we want now to know all of them. Well, he has not produced a single record, no records, not one, related to anything but the March 2023 accident. And he sent us medical authorization, but the court overruled the objection, and the request number 6 is for him to produce all the medical records. I get it that he thinks that I should go obtain all the medical records, but for his case, for him as the plaintiff, Mr. DePaz, he needs to put on his case and give me all the records that he's sustained injuries for, and the court's ordered him to provide. Now, if we go down to 19 and 20 requests for production, which the court also ordered him to produce, and that's on page 7 of D10.
All right.
19 is all records prior to the accident, and then we've got this response, plaintiff states none. And then we've got a response, does not have any responsive records in his possession at this time. And then we've got a second supplemental response. He sends me authorization for me to obtain the records. So we have no records ever produced. He did produce the March 2023 records, but we don't have any others. Number 20 is key because we ask for all documents and records related to any accidents after the one that's the subject of this case, which is March 10, 2023. So that would include the May 2023 accident. And in number 20, it's the same thing. He gives us an authorization, but there are records unrelated to medical records that we're also entitled to, and we have not received any of them. So I want to go through and show the judge my problem here with the case based on how he's answering these and not producing the records and telling me to go get the records, even though the court ordered him to produce them, overruled the objections. He did remove there were no objections to 19 and 20. He's just not producing any of the records. So I want to show the court my problem here. If we go to D9, which is plaintiff's first supplemental responses to his request for admissions, I need to show the court how they're continuing to play both sides on this case.
Okay, hang on a second. I'm having trouble with Box not being responsive now. All right, D9.
So D9, if you look at request for admission number 3, we asked him were you returned to full-time employment without restrictions after the accident? And he denies that. And he's seeking wages. And then in number 5, we said, admit or deny that your doctors discharged you from treatment for injuries you sustained in the accident. He denied that. So
I'm sorry, what's that second one?
it's RFA number 5,
Okay.
request for admission number 5. So the answers in the request for admission are, I continue to see doctors. I have not been discharged. I'm not released back to work. So we've got, you go find the records. We're not going to give you any records, but we continue to be, claiming injuries here that have not been resolved. And so if you go to Exhibit 12, here's part of my problem. So on September 7, 2023, his counsel in this lawsuit, Begum Law Group, filed this lawsuit in Ellis County. Okay. If we look at D12, 4 days later, his attorneys in Florida send this settlement demand to his insurance carrier, and all we have is this redacted settlement demand, and the court can see that at the bottom of the first page of Exhibit 12, the insurance carrier, rightly so, blocked out almost everything that we need to see what he was claiming in this May 2023 accident. Roberto immediately started, then it's blanked out, and as such made the conscious decision to seek medical treatment for his injuries. He presented to, so we don't know the name of who he presented to, on June 6th, where he was, and that's all redacted out. And the court can go to the next page, and it's all redacted. So
Let's do that.
yeah, the next page, there's nothing. And then I go to the following page and it says, I've enclosed the medical records and bills for your review. Well, I'm entitled to that. The court said I'm entitled to this document. And we can go to, can also go to D6, which is also from the Berman Law Group, if the court would like to get there.
Rasher, when you read from documents, do you mind reading a bit slower for me?
Yes, ma'am.
Okay, I'm at D6 now.
D6 is dated October 23, 2023, also from the subsequent accident, stating a new supplemental demand. And it states, enclosed, please find additional medical records and bills. Then it's redacted, and I don't know what records or bills these are from Exhibit D6. So we did our best to do our due diligence to get everything. The court ordered Mr. DePaz, who's engaged 2 different attorneys simultaneously, again, in 2 different cases, to turn over these documents. The only thing we have is we have no proof whatsoever, just his counsel saying, well, we called them and they won't give them to us. Well, why not do a DWQ, a subpoena to your attorney, or why not go get the records from the clinic yourself and give them to us? We don't, there's no effort. Just file a lawsuit where in the subsequent providers, you say you were not injured in my case and you collected on the subsequent case, but I don't have to do anything. All I got to do is give you a medical authorization, and that's it for me. I'm not required to prove my case. I don't care what the judge ordered. And medical authorization resolves everything. Well, going through the records, Judge, it does not resolve everything. I'm entitled to know what his attorney sent to the insurance carrier. I'm entitled to all those records. I need to know who he's seeing now. I'm entitled to all those records. Just the last record that I have of this man for the May 2023 accident is dated November 2023. And the last record I have for the March 2023 accident is August 9, 2023. My client has incurred substantial costs in this case to try and get to the bottom of what's going on. We discovered that there was false discovery answers, that the man was not injured in our case, and nevertheless, he proceeds to continue down this path. He's done some forum shopping, and my corporate clients shaking their head at this, and he doesn't follow the court's orders. And here we are almost 6 months later, and we don't have these documents. He just says, well, I reached out to my Florida counsel and he won't give me the records. But the Mr. DePaz apparently went to these clinics. Why can't he go get the records? Why do I have to spend another $50,000 trying to hunt and peck for where this man's seeing doctors and what his records are? And he's telling me a request for admissions. He's denying that he's been discharged. It's a wild goose chase and just a handout saying, okay, you pay me a bunch of money in a case and I'm not going to tell you what my injuries are. And I'm not going to give you the records. If you can find them, it's up to you. And so that is our problem, and that is why we move for default, because the plaintiff will just not, I guess, assist his counsel and go get the records or otherwise. And this case is just going on and on without any compliance. And so that's our reason for moving for a default on this case. If the plaintiff is going to work up his case and comply with the court's orders, do what he's required. It's not my case, it's his case. But I am entitled to all the records related to all of his injuries in this case, and he is required to provide them. I did say in a hearing before I found out that there was a May 2023 accident that if he would provide me a list and give me an authorization, I would get the records. Well, thereafter, we discover the rest of this, and now there's all kinds of loose ends here. So I've got a bunch of discovery responses that are not lining up, and I'm entitled to defend my case, and he's required to prove it. So that's my response and request for a default judgment, because this case has been going on and on. There's been plenty of time to comply, and there's non-compliance.
All right, thank you. Mr. Gonzalez.
Yes, Judge. We have fully complied with the court's December 31st, 2024 discovery order, Judge. Mr. Brasher is now moving the goalpost and asking for my client to do additional things. If we go to plaintiff's exhibit number 5, which is marked as Exhibit E to plaintiff's motion.
Hang on just a minute. All right, I've got that.
Judge, if we go to page 13, that's the hearing transcript for the July motion to compel hearing, which the order wasn't signed till December 31st, 2024. So it's the same as a hearing and the order. So we're referring to the same thing. But if we go to page 13 of that transcript, which is page 14 of, if we go by the 14 of 19 or page 13, at that point I told the court, my client doesn't know the name of the names, but Mr. Brasher has an all-state claim record that shows his prior, his other attorney's file and the other providers. He can get those records. I don't have an objection to him getting those records for the facilities for the other crash. My only objection is going back 20 years from a hospital not related to this. That's my concern. So then we go to page 16 of that transcript, Judge. That's where the court, speaking to Mr. Brasher, says, I'm going through your motion and checked off everything, and you're going to get an answer to interrogatory 5, Mr. Brasher. And then the court said, medical records of the prior injury, you're going to have that with authorization. You'll get that, right? Mr. Brasher, yes, ma'am. That's RFP 6, 19, and 20 are the ones related to the injuries. So at that point, that was the request Mr. Brasher asked for to the court. The court confirmed with Mr. Brasher.
Hang on. So Miss Williamson is is shaking her head no. That doesn't mean she disagrees with you. It means you're going too fast.
Sorry, Ms. Williamson. I'll slow down. Judge, so back during the July hearing, that was the relief Mr. Brasher requested. Now he's moving the goalpost, saying that my client should DWQ and do certain things. But that wasn't the issue here. Now,
I understand. Let me just say a couple things about that, though. So back in July of 2024, almost a year ago, you had a hearing in front of Judge Madeline Connor on the motion to compel. And we are looking at the transcript of that, which is Plaintiff's Exhibit E. And I'll stop briefly and just say we sent really clear instructions on how you should number and upload your exhibits, and giving them letters instead of numbers is part of the problem. The other part of the problem is we told you how to mark them, and they're supposed to be marked D001, P001, etc. And instead you gave them, or whoever did the uploading gave them names that didn't have the numbers. And so I'm having a little bit of trouble following you, but I've pulled up the hearing, which of course I wasn't the judge at back in July 30th, but it's my understanding, and you can tell me if I'm wrong, that at that hearing, only your client and presumably you were aware that there was a later car accident in May of the same year as this accident in March, and that the lawyer in that later accident had attached medical records to a demand letter, and your client only needed to get his lawyer to send him whatever it is he sent in the demand letter, and that would have avoided a whole lot of expense and hassle for defense counsel. So I'm troubled by that. And let me just say, my hearing was in November 26th of last year. My first hearing is Adno.
Thank you, Judge. It's defendant's motion for sanctions. And
give me just a minute to take down that other case and pull yours up. All right. The motion for sanctions is dated when?
It is dated.
I think I see it 10/31.
Yes, ma'am.
And I see defendant's response 11/25.
This was filed Saturday at 5:30.
And then a response from the plaintiff or
defendant filed a reply yesterday. We got the motion yesterday, response yesterday, and we filed a reply.
Right. It looks like it's defendant's response and plaintiff's reply. Although they're both called response. All right. I see them.
Very good, Judge. So what we have here is defendants have spent approximately a year to get documents through obstruction of the discovery process. We have violations of the Texas statutes, Texas rules of civil procedure, binding Supreme Court precedent. And what we have is we started out, and I'll just take the judge through this. We are going to share. We'd ask that our exhibits 1 through 26 in box be admitted for purposes of this motion. And I'm going to share with you.
Is there any objection to exhibits 1 through 26?
Some of those exhibits I hadn't seen, but to the extent they've been produced to me, yes, I don't have any objection. I just need to.
Hang on, let me pull that case up in Box.
We're currently on box exhibit 18. The reply kind of shortens all this up.
Hang on just a minute. This is defendants uploaded exhibits?
Yes, ma'am. Defendant's exhibits.
All right.
So I'm going to put back up.
So let me just say, defendants exhibits 1 through 26 are admitted.
Thank you, Judge. Okay, so I'm going to, it's okay, Judge, I'm going to proceed.
You may.
Exhibit 18. So this started out, we initially filed the lawsuit where the accident occurred, which was in Ellis County, Texas, and he filed the motion to quash basic medical information that relate directly to the subject accident. So in this case, the plaintiff was in a motor vehicle accident that is subject to this lawsuit, March 2023. Thereafter, we were unaware that he was in another accident, May 2023. It has taken us a year to obtain the medical records from the May 2023 accident through a lot of investigation, a lot of work, multiple motions to compel, and now this motion for sanctions. What we discovered was that there were actually records from the May 2023 accident that we'll look at in just a minute. The medical records say that the plaintiff was never hurt in the accident that's the subject of this lawsuit. He told us.
Tell me the date of the accident that was the subject of this lawsuit.
March 2023. March 10, 2023. And then he's been in multiple accidents, and we were not given any discovery as to any of the accidents, but we did a lot of investigation, and over a year's process and about $40,000, we've been able to uncover records that were at all times in plaintiff's possession. So we're looking at Exhibit 18, which was the start of a motion to quash basic discovery records, which started our first motion to compel. And then we go, and that was dated December 6, 2023. If we look at Exhibit 19, this was our first motion to compel, the motion to quash subpoenas. It's dated December 8, 2023. If we look at Exhibit 20, we noticed that motion to compel for a December 21, 2023 hearing. That's Exhibit 20. On Exhibit 21, plaintiff non-suited the case just prior to the hearing on December 14, 2023, before the December 2021 hearing. If we look at Exhibit 22, this is the first set of obstructive discovery responses. And if we go to interrogatory number 5 on page 4 of the interrogatories, plaintiff asserts physician-patient mental health privileges and violates his privacy rights when we asked him to provide a list of other healthcare providers in the last 7 years. We were unaware of the other car wrecks and that he had seen another medical provider and stated that he was not injured in the wreck and that he had hired another law firm. We go to interrogatory number 10, which is on page 5 of Exhibit 22. We asked for all motor vehicle accidents in which you have been involved in the last 7 years, and it's a false statement. Plaintiff states none in that response. So then, if we go to Exhibit 23, we were not aware that when we look at page 4 of Exhibit 23, Texas Pain and Injury, the initial report states that, and we did not have these records, we were not aware, we have never been provided them by the plaintiff to date. We obtained these through a subpoena against his insurance carrier. We never have any list of any medical providers that the plaintiff has visited through today. He claims he does not know who they are, even though he provided these records to his insurance carrier and collected the full amount of the insurance policy. These were withheld from us for a year and still have not been produced by the plaintiff. And it states, in prior medical history, prior to this accident, he was in good health and was completely asymptomatic. The patient's pain prior to his accident was 0 of 10, and post-accident was 8 of 10. So he denies that he's ever been injured before. And to Texas Pain and Injury, these records are proved up by subpoena and their admissions against interest, clearly not hearsay, that we had to obtain. Then if we go to another medical provider, which we're not aware of, Momentum Spine and Joint, which he saw, history of present illness on page 9 of Exhibit 23 states, patient reports pain started following a motor vehicle crash on around May 20, 2023. When it goes to his pain history, prior traumatic injuries, denies. Treated by a pain doctor, denies. Prior injections, surgeries, and current areas of pain, denies.
So did anybody go forward with a motion to compel before now?
Yes, ma'am. So then in this lawsuit, we filed a motion to compel. One moment. It should be on your docket, Judge. We filed a motion to compel. Let me find the exact date here. Let me see.
6/21.
Yes, ma'am. 6/21. And then the court ordered that.
And there was a hearing when?
Let's see.
July 31st, Judge.
I didn't hear your response, Mr. Gonzalez.
I see July 30th.
That sounds about
Sorry,
right.
Judge, that sounds about right. July 30th or 31st.
Okay, Judge. So that motion to compel was granted. Even we had a disagreement on what the judge ordered. We both submitted orders. Even in the plaintiff's order, he agreed to amend interrogatory number 5. His order is submitted to the court is 26. If we look at that, this is submitted by the plaintiff that he's going to answer interrogatory 5 within 14 days. To date, the only answer that we received is a false answer, even though all these records we've obtained. If we look at exhibit.
I'm sorry. So after the hearing on July 30th,
Yes, ma'am.
The order.
There's nothing, the court did not sign the order, but this is what plaintiff presented. We also presented an order that he would produce documents and answer discovery. We disagreed on what he had to produce. I'm sorry, the court reporter's shaking her head.
That means you're going too fast.
Okay, let me start over again then. So the plaintiff submitted a draft order. The defendant submitted a draft order. Is that okay, or is that we disagreed on what the court's order was. I don't know why an order was not signed. We both submitted it to the attorney, the staff attorney, as we were directed. However, there should be notes in the system of perhaps what the judge ordered.
So I'm looking at the docket note from July 30th. I do see that Judge Connor presided over a hearing on that date, and that there was a record by a court reporter. But if nobody ordered a copy of that record, then it hasn't been prepared. And
we ordered a copy. We submitted the record of the transcript. We emailed the court reporter numerous times, probably like around 10 times. We have those emails in the box under other materials. The court reporter responded at yesterday afternoon that she would prepare the record. At 3:30, she said she would have it within the hour. She produced the record close to 5 p.m. last night. We submitted that right after we received it to the court under the box under other materials.
And Judge, we haven't been provided with a copy of that, but we'd be happy for this court to review that. In any case,
well, it should be. He's telling us that it is in box for all of us to review. So,
okay. Well,
see,
no,
it's under Other materials?
Judge, and I guess I can get to it under my argument. I have as to what that record reflects.
All right, I see it. And it does say it was on the 30th. I need to take a quick break. Let's break for about 5 minutes. I'll be right back. Apologize for the interruption. Go ahead.
Okay, Judge. So I'm taking a look at the transcript in the prior hearing. The court on page 13 of the transcript ordered Mr. Gonzalez to identify the medical providers. He said, the court said, well, at line 13, why don't we do this? Why don't we do a year before and a year after for each medical provider around each rec? Because there's a lot of recs here. That's more than I've ever seen. You can put the provider's name instead of just to whom it may concern, not just this overly broad that you can send anywhere, like you said, from 20 years ago.
Just slow down a bit.
Page 14, I'll limit the 4-year time frame. And then you said that you can't find the providers, you don't know, but he's got a claim sheet that would show you the providers. Plaintiff answer interrogatory number 5 fully and completely, line 24s and 25. Second. So we asked for request for reduction 6, 19, and 20 related to the injuries. And the court said, so that's granted at line 17.
Of which page?
It is page 16, line 17. So that's granted. So in summary, on this particular motion, we've gone through 2 motions to compel basic discovery records. We have never been provided with the medical records that he submitted to the insurance carrier to get paid to this day. He has not amended the discovery responses to list the, and I'll show you, Judge, I'll go to Exhibit 13. One moment. To show you the current response that I've got. We don't know all the injuries this man sustained. And it is very difficult for us to take a deposition. We don't want to go ask the plaintiff. He's required to produce the documents. Here's his current answer. This is Exhibit 13. Can you see that, Judge? Interrogatory 5.
I do.
He says he does not recall the name of the providers he treated with for his subsequent crash, which is inaccurate because he has the records in his possession and has at all times had the records in his possession. But $40,000 later, we found them in insurance documents. And then if we look at interrogatory number 10, he provided a false amended answer, number 2, saying the plaintiff was not at fault. He re-aggravated some of the injuries. There is no documents anywhere that says he re-aggravated the injuries. The plaintiff told the doctor he was not hurt before this accident, admissions against interest. And if we look at what he was ordered to produce in 9 and 6 on Exhibit 15, to date, all we have is this nefarious objection that a physician and mental health privileges. That's already been overruled. He's been ordered to produce the records, and I still do not have the records. This has been a very costly for our client. It's abusive to withhold medical records that show that your client was not injured in a wreck for which he is wasting the court's resources and the citizens of Texas by filing to begin with. He's forum shopped, and we've had to chase this plaintiff and his counsel, and he has snubbed his nose at the Travis County local rules and filed a motion for sanctions that he once heard in this hearing, which he never even gave us notice of, and filed Saturday night. This man has no regard for the rules. We are having to spend tens of thousands of dollars on a case to uncover and investigate, and we still don't know all the injuries this man has sustained that have nothing to do with this lawsuit.
Thank you, Mr. Brashear.
Yes, ma'am.
Mr. Gonzalez.
Good morning, Judge. May it please the court. Ms. Williamson, if I speak too fast, please raise your hand. I'm sorry.
She can't raise her hand while she's typing.
Oh, okay, just make an ugly face.
That's
I
why,
do that.
that's why she shakes her head.
Judge, defense counsel has filed this unnecessary, unwarranted motion filled with untrue accusations. He's trying to rehash issues. He filed a motion to transfer venue to Ellis County. It was denied. His motion to compel was largely denied, Judge.
Let me just stop you and say I've read some portions of the transcript from the hearing on July 30th, and it appears that the court actually overruled many of the objections and ordered you to produce information about the medical care for a 4-year period. Have you done that?
Judge, and I'll get to that. I apologize. If we look at exhibit, it's exhibit E to defendant's, to plaintiff's response.
I'm sorry, it's exhibit what?
E as in Easter,
To whose response?
to plaintiff's response. And I'll put it up here for the court.
Up on my screen.
You scroll down to the bottom, Judge. Back on May 20th of 2024,
I'm sorry. You said it's the bottom, but okay, I'll look at yours because that's not what's at the bottom of mine. Go ahead.
Back on May 20th of 2024, I told plaintiff's counsel, we cannot agree to a blanket authorization. We cannot agree to employment records. There is no relevance. We can agree to go 5 years back with medical records at the start. So our whole issue with the DWQs that were filed back in Ellis County and filed here in the Travis County lawsuit is that the medical authorization defense counsel sought was not limited to time, Judge. And we expressed that to the court back on the July 30th hearing. So, and this is where the allegations defense counsel make are overtly false, Judge. If we go to the transcript, we start with page 8. Our issue with the scope, the authorization did not have a time limit, Judge. That's what, like back in May, we had already told defense counsel we can agree to a 5-year limitation. And then with the cell phone record, Judge, she wanted 24 hours of cell phone records. There's no allegation of contributory negligence there's no allegation of contributory negligence in defendant's driver's answer. So we took the position that the cell phone records were not relevant. He wanted 24 hours. We asked the court, Judge, so if he wants cell phone records from an hour before, that's fine, but it's 24 hours before. So again, Judge, I have an issue with the scope given the facts of the case. The judge said, okay, I'm going to do 1 hour for cell phone records. So his request for cell phone records, Judge, was limited from 24 hours to 1 hour. Then he wanted his whole employment file. Even though there's no contributory negligence allegations, he wanted his whole employment file. If we look at exhibit K, this is the authorization defense counsel sought or compelled my client to sign for his employment records. All applications for employment, resumes, records, all positions held, job descriptions of position held, payroll records, W-2s, performance evaluations and reports, driving records, vehicle maintenance records. It was a whole list, Judge. The court in the July hearing, the court said, I'm going to do 1 hour for cell phone records. The wage records, we don't need all that other stuff. So like resumes and all that, I mean. So the court limited his wage authorization as well. And then, Judge, I told the court as an officer of the court, Judge, what's going to be the scope of the authorization? Our client, he's entitled to all records related. We just want to make sure we have an opportunity to say what we have to say within this authorization. Page 13, Judge, again, during the testimony, my client doesn't know the names, but Mr. Brasher has an Allstate claim record that shows his other attorney on that file and the other providers. So he can get those records. I don't have an objection with him getting records from facilities for another crash. My only objection is getting records from, say, 20 years ago from a hospital not related to this. That's my concern. So, Judge, back on July, we told the court we have no objection to Mr. Brasher obtaining other records. Again, I told the court 4 or 5 years, I don't have an issue with. I just have an issue with an unlimited time frame. The court. So I'll limit it to a 4-year time frame. Then you said that you can't find the providers. You don't know the name of the providers, but he's got a claim sheet that would show the providers. He, meaning Mr. Brasher. Mr. Brasher responded, "We don't represent Allstate. I don't know who his providers are, so I have to try to subpoena Allstate and that sort of thing." But he would get copies of all those depositions on written questions. The court, sorry, I'll slow down. The court, I'm going to order that plaintiff answer interrogatory number 5 fully, completely, to the best of your ability, produce the assigned authorization for a 4-year time limitation. The court, I'm going through your motion and check off everything. You're going to get an answer to interrogatory number 5. Mr. Brasher, the court, medical records of the prior back injury. You're going to have that with the authorization. You'll be able to get that, right? Mr. Brasher, yes, ma'am. That's RFP 6, 19, 20 are the ones related to those injuries. Judge, and I want to point special attention. Judge, I want to point special attention to this part of the record. The court asked Mr. Brasher directly, medical records of the prior back injury. You're going to have that with the authorization. You'll be able to get that, right? Mr. Brasher responds, yes, ma'am. That's RFP 6, 19, and 20 are the ones related to those injuries. Mr. Brasher affirmed to the court he was going to obtain those records via authorization. And then,
Mr. Gonzalez,
yes, ma'am.
that would require that you give him a list of the doctors that he'd seen in the past 4 years, right?
Correct, Judge. He already had a list of the providers that he provided to us. It's exhibit exhibit O. Here's exhibit O. Here are the doctors. Now, Judge, the issue here
Sorry, Mr. Gonzalez, you said that was exhibit O, but I saw exhibit K on the document.
It's exhibit O that defendants produced as exhibit K to their motion to compel. So we received that exhibit as exhibit K to defendant's motion to compel. So, Judge, the issue here is that after the July 30th hearing, plaintiff's defense counsel drafted a motion that was not consistent with the court's ruling. And I have here. Can the court see the motions in front of it, Judge? In front of her? Sorry.
I do.
The proposed orders. Judge, so my suggestion was order granted in part and denied in part, because his relief for non-limit authorization was limited to 4 years. The employment records were limited. Cell phone records were limited. Counsel wouldn't agree to changing the title. There, also, as you saw.
So I guess here's the thing that I'm struggling with. Y'all did not, I take it, ask to go back in front of Judge Connor to get her to rule on the differences between these two orders.
No, Judge. And again, the record is clear that the judge asked defense counsel if he was going to obtain the request for productions via authorization, and he put yes, ma'am. She never overruled the objections or asked plaintiff to produce those records. And the issue was, Judge, he wouldn't even limit it to 4 years prior to the accident for this medical authorization, as the court clearly stated numerous times in the hearing. So defense counsel filed a motion under oath stating that plaintiff's counsel has failed to comply with the court's order. Judge, there is no signed order. Further, even though there's no signed order, Judge, plaintiff's counsel gave defense counsel the signed authorizations so he can obtain all those records. And plaintiff's counsel has no issue supplementing interrogatory number 5. However, once the dispute arose over the scope of the written discovery that the court had granted, defense counsel never attempted once, Judge, to confer with plaintiff's counsel about the pending order. Instead, as their timesheets reflect, they were already drafting a motion for sanctions. So instead of conferring with plaintiff's counsel, they were too busy drafting a motion for sanctions. The court limited the medical authorizations and DWQs to 5 years prior to the crash. And they're asking this court for plaintiff to pay them for legal work that they needed to do, Judge, for plaintiff asserting his rights under the rules. So again, Judge, the statement that plaintiff has failed to comply with the court's order is objectively false. There is no court order. As the record reflects, it was defense counsel included relief that the court did not agree to, and he did not include limitations that the court had ordered. For that reason, that's the reason the court never ordered the original order.
All right. So let me just say this. it is unfortunate that you did not get a written order from the hearing on July 30th. If that ever happens with me, where I make a ruling on the record and then y'all send me two different versions of the order and I don't sign one of them, I generally would either get the record and figure it out and sign one of them, or I would ask y'all to come back so we could hash out what the order ought to be. Unfortunately, the judge who held the hearing back on July 30th didn't do either of those two things. So there is no written order for me to enforce, nor is there a written order to base a motion for sanctions on. I know that's not an ideal situation for anybody, and it's unfortunate, but that's where I find myself. I think you need a motion to compel before you have a motion for sanction. I mean, an order compelling before you go after the sanctions. Technically, I suppose you could ask for sanctions at the hearing on the motion to compel, but I guess that didn't happen. I haven't read the whole transcript. But it seems to me that what y'all need is an order compelling based on the rulings at that hearing back on July 30th. And
Judge, may I add one other thing?
well, let me just say this before I get interrupted. And that is that Judge Connor is leaving the bench at the end of this year. And I don't know if she's even available between now and the end of the year. So basically, I have two choices. One is to ask her to give y'all another hearing so you can hash out what that motion to compel should have, that order to compel should have said, or I can ask her if she wants me to take over at this point, since I'm sure she's fully busy with wrapping everything up before she leaves the bench. But go ahead, Mr. Brashear.
Yes, ma'am. So the purpose of the motion today, regardless of any prior motion to compel or otherwise, and she did rule that, and he agrees that he was supposed to answer interrogatory number 5, provide the medical providers, both in his order and mine, and she did rule that he was to produce the documents on the record. So we do have the record. We know what she ordered. But regardless, there is no requirement under the Texas Civil Practice and Remedies Code, the Texas Rules of Civil Procedure, or the great Supreme Court cases that we have that bind us and tell us what we have to do in discovery. He was required to produce the records in his possession, which we requested in request for production, which to date have never been produced. I am not required to go track them down, and he has cost us $40,000 and is a clear abuse of discovery process. Thank you, Judge.
Judge, I may respond. Judge, those records are not in my client's possession. He hired another attorney who sent a demand out. That's just a false statement. The initial disclosures, Judge, and I produced a copy of I believe it's Exhibit L, Texas Civil Practice Remedy Code 195.2, number 10. So this is, in a suit alleging physical or mental injury and damages from the occurrence that is subject of the case, all medical records and bills that are reasonably related to the injuries or damage asserted, or in lieu of an authorization permitting the disclosure of such medical records and bills. We produce an authorization. That's what defense counsel asked for during the hearing. The Judge Connor asked him point blank, you'll be getting the records from the prior hearing via the authorization. He answered, yes, ma'am. So he got the relief he wanted, he asked for. Medical record, going back to the transcript, the court medical records of the prior back injury, you're going to have that with the authorization. You'll be able to get that, right? Question mark, Mr. Brashear, yes, ma'am. That's RFP 61920 related to the injuries. So Mr. Brashear lost that motion to compel in the sense that the court agreed with plaintiff's counsel and limited the scope of all 3 authorizations. He told the court he needed the authorization so he can get the records for the prior crash. Plaintiff's counsel agreed. Now he's asking plaintiff's counsel to pay him for the work that it's allowed through the rules. We're allowed to provide an authorization in lieu of the records, Judge. That's the black and white letter of the law. You're on mute, Judge.
Sorry. Thank you for the arguments. I'm going to take this matter under advisement. I'm going to read the transcript. I'm going to talk to Judge Connor if I can, and I'll get y'all a ruling as soon as I can.
Thank you, Judge.
Thank you.
May we be excused?
You may. At the time, I don't think we had the transcript from the July 30th, 2024 hearing, but if we did, we didn't have an order, and the order was signed on the last day Judge Connor was in office on December 31st of 2024. And so I didn't grant sanctions until after I read both the transcript from July of 24 and Judge Connor's order and heard argument on November 26th of 24. So by January 8th of 25, when I made my ruling, there were a whole lot of new things that I hadn't been aware of at the hearing in November. And hang on just a minute. So I'm looking for. So I awarded sanctions in the amount of $18,374.57. Then, Mr. Gonzalez, you all filed a motion for me to reconsider, and I denied it in an order on March 17th of 2025. So that brings us to now, and now I'm seeing there were demand letters with all of the medical records attached that your client's other lawyer had. And in terms of possession, custody, and control, I can't imagine that there'd be any dispute that your client had control over his lawyer's file. The law is pretty clear, but the file belongs to the client and not to the lawyer. So how is it that you should not have been getting those documents from your client's other lawyer and producing them to Mr. Brashear?
Well, Judge, first, we did make attempts. If you go to Exhibit F, to plaintiff's exhibits.
It takes me a minute to get there.
And judges, for the record, I spoke with my client. He states he has not settled that other case and that he cannot get a hold of these attorneys. They're out of Florida, so he hasn't been deposed. So I don't know what's going on with the other counsel. The ruling in August, the request at that point was for authorizations and for the name of the providers. That was the only request asked for by Mr. Brashear.
That was the request in the motion for sanctions, but it wasn't the request in the discovery requests themselves.
Correct, Judge, but whenever we had the hearing, that was the request he asked for and he agreed with. So we were trying to comply with that request, with that court order. And even if you go back to
which was fine until everybody learned that your client's other lawyer had the very documents that the defendants in this case were looking for and did not produce them.
Correct, Judge. And my client made many attempts. He told me he made many attempts to contact that attorney. He doesn't know what's going on in that file. It's already been 2 years since that May 23 accident. It might not even have file suit. He doesn't know what's going on.
It's too fast, Mr. Gonzalez.
Sorry, ma'am. He says he hasn't gotten a penny. He hasn't been deposed. And if we go to emails from my office on November 19 on Exhibit F, Judge, my office said, "Good morning. Please see attached letter of presentation." And then
what page are you on F?
Yeah, so we scroll to the final page.
Okay.
It should be an email from November 19.
I see it.
So we, at that point, we're like, all right, let's go above and beyond. We called them and they said, send us a letter of representation. We did that on November 19. On December 12, we said, good morning. We're following up on the information requested. I have been calling your office and leaving messages with the reception as well as voicemails. If you could please get back to us as soon as possible, it would be much appreciated. December 16, they finally responded. Our system was down last week. I will talk to the attorney and get back to you. January 3rd, I asked again, good morning. We are awaiting a response on this. We have a court order we need to comply with. Please produce the name and records.
Mr. Gonzalez, I'm trying to make a record for you, sir, but you keep speaking faster than my abilities allow me to capture the record. So I'll ask you one last time to please slow down for me so I can do my job. Otherwise, I can't keep up.
I'm sorry, Ms. Williamson. Judge, so we followed up on November 19, December 12. They finally responded on December 16 that they would talk to the attorney. I followed up on January 3rd. They responded that they would reach out, and they still hadn't. I followed up on January 6th. Good morning, Mariana. I want to confirm your office will be reaching out to us today. We need the information requested ASAP. No response, Judge. Again, my office followed up again. Good afternoon. I am following up on this information. So, Judge, those other records are not in our law firm's possession. I asked my client to call the law firm. He says they're not answering. I made multiple attempts as well, Judge. And I understand the frustration from Mr. Brasher. But in terms of where we're here today, it's from the allegation that we haven't complied with the court order from December 31st, which we have. We've removed the objection. It's a supplemental answer, not an amended answer. We keep it in the same pleading or the same discovery response so that it's consistent and we can see what our prior answers and objections and responses were. But if Mr. Brasher had a question as to whether that objection remained, he could have just emailed me or called me. I would have told him those prior objections we don't stand by them. We have removed them in accordance with the order, and we supplemented our answer. We haven't made our answer subject to the prior objections. We just supplemented without an objection. So in terms of the December 31st order and the July hearing, we've complied with exactly what the court ordered when Mr. Brasher asked for. We've gone to the other attorneys, asked them for records. They haven't given to us, Judge. And while I understand the frustration, I don't believe those are grounds to default against my client on this case.
Judge, if it pleases the court, I have something very important to show the court.
Go ahead.
Exhibit A to our motion for sanctions, and it's a part of the court's record. It was accepted as one of the exhibits. I didn't realize that they were going to claim today that Mr. DePaz was not paid in the other case. I'm going to share a screen right now. Counsel should be well aware that Mr. DePaz was paid full progressive remitted payment. And this is part of the redacted documents we got from Progressive. It shows advice for payment, law offices of Berman and Roberto Lopez DePaz, March 29, 2024. There's not an ounce of truth that ever comes out in this case from the other side. This man was paid. If he wants his own medical records, he can go to his providers and get them. Mr. Gonzalez knows how to get them from his medical providers. He does not need to go to his lawyers, and he can subpoena his lawyers. So to say that he doesn't have them in his possession, they're his medical providers and his attorneys. That is just not true. And that is Exhibit 8 to our motion for sanctions, which has already been heard by this court and ruled on.
So I do think that the behavior in this case is worse than I think I've ever seen in my 34 years of practicing law before I took the bench and in my 8+ years since I've been on the bench. I think that what happened here may rise to the level of fraud. That said, the order did not require that he produce the records. The order only required, because it's what you asked for, that you get a list and a medical authorization, and you would take the medical authorization and get the records from the list from each of the doctors on the list. And I get that now in retrospect, knowing what we all know, that should have been part of the order from December 31st. That was based on a hearing on July 30th of 2024, when everybody knew a whole lot less except for the plaintiff. Let me just say, I don't mean to cast aspersions on you, Mr. Gonzalez, or your firm. I have no idea whether your client lied to you or told you the truth, but you are charged with the knowledge that he had, and he knew that he had another accident, and he knew that he had a lawyer who was making demands to get a settlement in that other case by sending medical records. And that claim was apparently settled and paid according to Defendant's Exhibit 8 to their motion for sanctions back in March of 2024, which was a year after the accident that's at issue in this case, and less than a year after the accident that was at issue in the case that settled. I have to say that I agree with Mr. Brashear that when objections are struck, they should be removed from the answer. But I understand your position is that they didn't need to be removed from the answer because your specific answer was not subject to that objection. And what exhibit is that I look at for that?
That is, it's D11 and D10. D11 is the supplemental interrogatories, and D10 is the supplemental request for productions, but he just provided supplemental answers. It's a strange, I haven't seen this before, but I guess in the terms of pleadings, it's not amended. It doesn't change the prior answer. It just adds to it. And I don't know who he's seeing or what medical. And I mean, we're just at a loss as to.
Well, and let me just say, I have no doubt that if this order required him to turn over the records to you and he had failed to do so, that I would strike his pleadings a granted default. Unfortunately, that's not what the order required. So I think what we have to back up and do is have an order that requires that. So what I'm going to do today is I'm going to order that the plaintiff obtain all of his medical records and that he produce those medical records for the last, would you say, 4 years before this accident?
Those RFPs are for 7 years, but this one was 2 months after the accident. So it's clearly within that scope.
All right. Well, let's say 4 years prior to the accident to the present. And those redacted demand letters that attached to those, I'm going to order that those be produced without redaction. That doesn't mean that they're going to be admissible, but they're clearly relevant to the inquiry that we're dealing with today. So, and all the attachments. So, Mr. Gonzalez, your client's going to have to demand that his prior lawyer turn over his file to him. And since that case has been settled, the sooner he does that, the better. How much time?
Just for the record, he has not been deposed. I don't know if he's received a penny from his attorney to him. His attorney might have gotten paid. He states he hasn't received a penny. So I understand where the court is coming from, Judge. And with an order, that will help me send it to this other firm and tell them, look, we have an order. You better give me all your file. And I'll also give that order to the client so he can personally, I don't know where, they're out of Florida. So
you need to slow down a bit for Ms. Williamson.
So yeah, I'll email that order to that law firm, make them aware that there's a court order forcing them to give us those documents, see if that gets them to act. I'll also give it to the client, have him go to wherever he went. I don't know. I doubt he went all the way to Florida, but I'll make him aware. So if the court can give us, say, 30 days to send that order to the other attorney and see if they'll give us the records this time.
Judge Soifer,
y'all don't have a trial setting in this case.
We do not, Judge.
Do you have a scheduling order?
We do not, Judge. We're, I think, waiting to resolve these issues. The other thing is, could I get clean answers to my discovery request? Just, response. What's your current response? Your current list of medical providers? last time you saw someone so that I'm clear as to what the injuries and the allegations are in the case, I would appreciate that.
I have no objection to that. And just for the record, it would be interrogatory number 5, request for production 6, 19, and 20 as outlined in the order. Mr. Brasher, are those 4 items that you want me to amend and clarify?
And request for admissions 3 and 5, because those are contradicted.
RFAs.
And what document was it that you were showing us?
RFA, the request for admissions are,
No, I meant the settlement information for that other case.
is Exhibit 8 to our motion for sanctions that should be in the court's record. And our hearing that you held, Judge, whenever that was, November 2024, it should be Exhibit 8 uploaded to BoxyBot.
Okay, I'm actually, it was it Exhibit 8 to that motion as well? I have it now. It is. So let me just say, I'm taking judicial notice of the file in this case. There are 58 items in the file. And in particular, right now I'm looking at Exhibit 8 to defendant's motion for sanctions dated October 31st, 2024.
To clarify, I'm sorry, Judge.
Go ahead.
B8 that's marked for purposes of today's hearing is not the same Exhibit 8 that you're speaking about, Mr. Brasher?
Correct. Yes, ma'am. Exhibit 8 for the prior hearing in BoxyBot was the motion for sanctions hearing that Judge Soifer was heard in November. And we have a different Exhibit 8 in this current hearing uploaded to BoxyBot.
All right. Yes. So I do see that in the court's file in that October 31st, 2024 filing. So I am going to order that a full copy of Exhibit 8 that's not redacted, and that is the Exhibit 8 from the October 31st, 2024 hearing. And then also, what was the information on that letter that had everything redacted?
It was let's see. There were 2 letters, D12 and D. I have to get back to defendants.
D6, the supplemental demand.
Yes, D6 and D12.
12 and 6 for today's hearing. Are the things that I'm ordering to be produced unredacted and with all attachments. And Mr. Brazier, do you have any objection to the 30 days that Mr. Gonzalez has asked for?
We do not have an objection, Judge. And then D9, our request for admissions. We want to make sure if 3 and 5 are accurate, we want all of the subsequent medical records for whoever he's seeing now.
Judge,
Or he needs to revise those requests for admissions.
Judge, my only issue, because I don't want to be before the court again on a misunderstanding on this issue. Request for admission 3 is admit or deny you return to full-time employment without restrictions after the accident. So if he was with restrictions a month and then return, or a year, it doesn't specify. It just says admit or deny you return to full-time employment without restrictions after the accident. So if he admits it, it means that he never had restrictions. Or if he denies it because he had restrictions for a month. So I don't know what Mr. Brasher wants in that RFA.
Right, well, let me make it clear. The response to the RFA, both RFAs 3 and 5, should be truthful. And I'm not going to order you to answer it a certain way. I'm going to order you to make sure your client answers it truthfully. If he can neither admit nor deny it, the rules suggest that he explain why he can neither admit nor deny it. Otherwise, he should admit or deny it. of course, we know that at the time of the final trial in this case, if it turns out his admission was false, then the amount of money that it takes the opposing party to prove it false is appropriate in sanctions. So we're already at over $18,000 in sanctions, and you'll just need to explain to your client that he needs to answer everything truthfully. And so I'm going to order that you produce an amended response to interrogatories, an amended response to the request for production, and an amended response to the request for admissions. And those amended responses should not include any exhibits. I'm sorry, should not include any objections.
And
All
so
right.
just to be clear, those are for interrogatory 5, request for production 6, 19, 20, request for admission 3 and 5, correct?
Correct. All right. If he does not get you everything I'm ordering in 30 days, then I will grant a default judgment. In the meantime, I will entertain a request for some, well, let me do it all at once. I will entertain a request for monetary sanctions for the need to have this hearing, and as well as the possible striking of plaintiff's pleadings if he doesn't fully comply. So, Mr. Brazier, could you prepare an order memorializing all of my rulings here today?
Yes, ma'am.
All right. And when can you get that to Mr. Gonzalez?
Let's see. Can you give me until Tuesday?
Yes.
Judge, and may I request 30 days from the date the order is signed? That way I can forward that order to the other attorney, and they have a clear deadline as to when we need to comply.
So the compliance date is going to be 30 days from today. And the order, my preference would be to have the order in hand today or tomorrow.
Okay, I'll do that, Judge. This is urgent, so I'll do that.
All right. And if you have anything in there that you're not sure about, I can check my notes and make sure that everything that I believe I've ordered are in your order. Go ahead and send it to Mr. Gonzalez and to my court by replying all to the email that set up this hearing. And Mr. Gonzalez, if you have an objection up to the form of the order, or you think it doesn't comply with what I've asked, I'll give you until the following business day at 5 o'clock to let me know what your objections are if you're unable to work them out with opposing counsel.
Thank you, Judge.
All right. Anything else?
Just for him to provide me amended answers and responses, is that going to be also 30 days?
Yes.
Okay.
And the doctor's records and the full list of providers and the unredacted documents.
Got it, Judge. I can draft that up.
All right. Well then, thank you. Y'all are excused.
Thanks, Judge.
Thank you. All right. So we're going to take the court cases in the order that I just announced them, and we're going to start with the Canale case. Do you all want a record?
Your Honor, I don't need a record.
That was one of the things I was hoping to clarify with your assistant. What does that mean? Do you have to decide beforehand if you want to have a record of the case?
Yeah, so it means you can ask to have the court reporter take down every word that everyone says, and then later on, you could order a copy of the transcript if you need it or not. Yes, she does need to know whether she needs to make a record. She takes shorthand and writes down what everybody says, but it's a little bit harder to do on Zoom. And so if you want a record, that's fine, but we'll need to make sure that everybody speaks at a normal rate of speed, because she is certified to 225 words a minute, which is a lot, but when people get wound up, they can speak a lot faster than that. And the other problem on Zoom is that if two people are speaking at once, the voices cut in and out, and she can't get all of what either person is saying. So we have to be really careful to speak one at a time if we have a record being made.
But you decide after the fact if you want to actually order the transcript?
Correct.
So she might kind of do the work for nothing if you don't order it?
It is her job. It is her job. But yes.
Because what I'm used to is they take a video recording and then they only transcribe it from the video if you order it. So it's a little different here, I guess.
Yes.
I mean, I hate to have her do work for nothing. So I guess I'll pass.
All right. So you're not asking for a record.
I'm not. But can you tell me, are we live streaming on YouTube right now?
Yeah. Yes, we are. When we have court in person, the courtroom is required by the Texas Constitution to be open to the public. And live streaming on YouTube is the equivalent of keeping the courtroom open to the public. I doubt seriously there's anybody watching on YouTube.
I watched you this morning.
You did? All right.
Yes.
I used to tell people the only people watching were usually my mother and maybe somebody's staff, but my mother got over that pretty fast.
Well, I ask because I've been monitoring the live streams for a long time, like months, probably a year. And this morning was the first time I ever saw a Travis County one come up. It's all the other Texas counties. So, and I looked for you all week. So where were you? Are you just working one day this week?
No, it's because the rest of my dockets have been in person. So we don't live stream if we're not on Zoom.
I see. Okay. Got it. Okay. Thank you for clarifying all of that.
Yes. All right. So, Mr. Holtzman, it's your motion.
Yes, Your Honor. So this is Jennifer Canale was in a personal injury incident at Whole Foods. So this is a premises liability case. We're filing the motion to withdraw. We filed it back in November. Some previous dates didn't work for Ms. Canale. So we've been trying to get this motion heard as fast as possible. Essentially, we just have a fundamental disagreement as to the strategy and the case in general. We're just wanting to withdraw. We're not taking any attorney's fees for the case. We're simply just putting a lien for the $8,000 in expenses that we put towards the case, and that's because we had to order her medical records, and we hired an expert to establish liability against the defendants. And so we're not taking any attorney's fees. We're just wanting to withdraw from Ms. Canale's representation. She does not have a current attorney, and we've notified her, like, hey, let us know if you have another attorney that you'd like to sub in, but none to date has happened.
All right.
And I just don't want to, I know I've got defense counsel here too, so I don't want to disclose too much about the case because I don't want to prejudice Ms. Canale's case, Your Honor.
All right. Fair enough. So Ms. Holder has already said she is not opposed. So Ms. Canale, are you opposed?
So I have 6 points that I need to address. So as far as the withdrawal part of it, I do not oppose it. So we're all on the same page as far as Mr. Holtzman withdrawing from the case. Like he just said, we've already agreed he's waiving the attorney's fees. So that's done. But I have 4 other issues, which is why we're here today, and I didn't sign off on the proposed order. So mainly, I am objecting to his request to maintain an expense interest at this time, and I would request that the court expressly reserve all determinations regarding claimed expenses for a later hearing. I would like the court's withdrawal order to make it clear that the withdrawing attorney shall have no lien, assignment, or claim on any future judgment or settlement in the case unless and until such a claim is specifically adjudicated and approved by the court. And there's several things, like Mr. Holtzman said, because defense counsel is here, I don't know how much I want to get into it, but the fees were excessive. Well, let me finish. So as far as they're maintaining their expense, my considerations as to when to make this determination, I would like to know today if the court has a preference on if this should be determined at an upcoming hearing soon or after the trial. And I have two considerations for that. So first, obviously, the impact on the litigation strategy. So as of now, I do not intend to use the majority and probably none of any of the items or materials or services that the attorneys obtained and paid for. They're not part of my strategy. I did not request them. I did not approve them. However, if I am ultimately going to be forced to pay for those expenses, I might incorporate some of them into my case to try to recoup some value, however minimal. And that could alter my trial preparation and shift how I present my case, not because the materials are helpful, but because I'm being financially responsible for them. And so I would try to have some benefit. He said they were $8,000. It's actually almost $9,000. It's $8,850.03. Although he sent me several different forms with different numbers. We've been going back and forth for more than 6 months where I've been trying to get receipts, invoices, and I'll get into that in just a moment. But then the other thing I wanted to bring up is that, obviously there's the risk to adjudicating the matter in open court and disclosure of privileged information that defense counsel may try to use. So if we were to litigate the fee and expense dispute before trial, it would compel me to disclose privileged communications. And so that's, something that I need to consider. So first and foremost, I guess the question I would have is if this is a determination that I am even able to make, or if the court determines when fee disputes are adjudicated. And in either case, I would ask if there's an option to disclose our privileged communications in a sealed record that opposing counsel cannot review, or an option to have email communications reviewed in camera by the judge. And do you want to comment on that, or should I finish my last couple of points?
You can finish.
Okay. So in line with that, I would like the court to order today production of all third-party agreements. So as I mentioned, since December and really before, really for about a year, but I really started making consistent demands via email December 15th. And I, of course, have all of those communications. Requesting the production of all contracts, fee agreements, or other agreements that were entered into with any vendor, expert, service provider, or third party for which they allege I'm financially responsible. And I'm contesting the legitimacy and necessity of virtually all expenses incurred. And so these include highly inflated service charges, multiple billing layers for unnecessary or duplicative services, and third-party vendor costs that were not disclosed to me and were never authorized by me, and which I would not have authorized had I been properly informed. So just as a couple of quick examples, not to take too much of your time, but I was charged almost $2,000 to retrieve medical records that I already possessed. I was charged $1,200 just for travel expenses for an engineer from San Antonio to survey the location and the accident, which is, in my opinion, highly unreasonable when there are many qualified professionals available locally in Austin. I was charged 250% more than the market rate for service of process. I was forced to use a mediator whose involvement not only worsened the dispute, having the mediation end with us farther apart than when we started, but I was also charged 400% the market average value, market rate for that mediator. I was charged hundreds of dollars to certify from 2 separate providers that I had no bills from them. I was repeatedly charged rush fees for documents where there was no rush to receive. I was charged extraordinary inflated rates for all expenses that double, triple, or quadruple the market rate. And I've made multiple written demands to my attorneys, sending numerous emails requests, like I said, since December 15th. I've also contacted their primary vendor several times via phone and email and made an explicit demand for documents in an email sent on April 13th, 2025. And that was something that I was going to upload to the box, but I was not was not authorized to have access. And so that's something I hope I can speak to your assistant about this afternoon to get that worked out. But in that April 13th email, I identified 12 specific records and 14 explanations. So I won't waste your time with that, but essentially not a single document was produced. I was ignored repeatedly by my attorneys, by the vendor. And so I'm asking the court to order that my withdrawing attorneys provide all contractual agreements, billing records, and third-party arrangements related to any expense claims so that I can properly evaluate them and challenge any amounts they claim I owe. And then number 5, almost done. I would like the court to order my former attorneys to redact my home address from all court filings. I made repeated explicit instructions from the onset of representation that for safety and privacy reasons, I only use a mailing address for all of my legal documents, and that was to be used in any public filing. And despite my explicit instructions, my attorneys repeatedly disclosed my home address without my consent. They also disclosed my personal email address, which I never put on any of my legal filings. And I would like those documents properly redacted or modified. And finally, number 6, this is not for my attorney specifically, but more an issue for the court. So this is my first experience in a Texas court, but I have quite extensive experience in Illinois courts. And from what I have determined, I am going to run into the same issue here in Texas that I have had in some of my cases in Illinois, which is an inability to access the public record. And I am entitled to have the same access to information and legal research tools that's provided to opposing counsel. And it seems to be the situation that only licensed attorneys are able to have online access to the public record. And I found that to be incredibly problematic in my previous experience in litigations, to the extent that we're in the process of trying to transfer venue for 2 of my cases because it has been such a problem that I cannot access the online public record. I also have learned that in Texas, just like in Illinois, licensed attorneys are provided additional tools and resources through their bar membership to databases such as VLEX. And so I would like to ask to have essentially just the same equal rights, equal protection under law, the same constitutional protections of due process to be able to have the same access to information as my opponent. That's all.
All right. Did you want to add anything, Mr. Holtzman?
Judge, those records that we ordered, it's from the Legal Connection. We use them on every case. It's just a records company. They charge a fee. We have got to get these records, as you know, in admissible form. So these are deposition upon written questions. They're not cheap. You know, it is what it is. They cost money for us to have them admissible in Texas. It was a premises liability case. We thought it was necessary to have an expert testify as to the liability of Whole Foods and the owners of the parking lot. Let's see, I guess some of the other things that Ms. Canali brought up. You know, the contract that she signed gives us permission to act on her behalf. You know, we didn't step outside the lines here, Judge.
All right. So I'm going to grant the motion to withdraw. Have you sent us a proposed order?
Yes, Your Honor.
I don't see anything in box. And I don't see one attached to the motion.
Okay, I'm sorry. I can send that now. I'm looking at it right now. It's been signed by other defense counsel, just not Jennifer Canali.
All right. You want to go ahead and share your screen so we can look at it and we can find out if Ms. Canali has any objections to the form of the order.
Yes, Your Honor.
So as I mentioned, I'd like my home address removed and my personal email.
And Judge, we just put that in there because the Rule 10 of the Texas Rules of Civil Procedure require us to do that. And the Supreme Court updated it in November 2024 to include the email address as well.
So the rules do require that if you don't have a lawyer that people be able to get you documents and information in the case. And that's the reason why the rules require the last known address of any party whose lawyer is withdrawing, so that people know they can no longer send records to your prior counsel and where and how to send them.
I understand that. And that's why I use, like I said, I have extensive litigation experience. I use a mailing address and I use an email just for legal purposes. And so I have contact information that can be put on there, just not that particular information.
All right. You want to tell us what address and phone number and email address you want to include?
Yeah, I can do that, or I can email Mr. Holtzman after, or however you want to do it.
All right. So,
Judge-
Your Honor, may I interject? As defense counsel, I need that information.
so she's telling you that she has another set of addresses that will be available and that will reach her.
Ms. Holder, I will go ahead and email you. You have my email. It's the email that's been used that I've been copied on and in our last couple exchanges, so that you can contact me with that email you're already using.
So is that different from the one that we see on the screen?
That's correct. It is different. And we're already using a different email. Yes.
All right.
Miss Connolly, I'm so sorry. I have not communicated with you directly at all, so I will need that email address. You can get my email address off any of these pleadings and send it to me. I am not allowed to contact you until this order is signed.
Okay. I just, if you want to check what you emailed last night, I'm on that string as one of the contacts, but I will email you. But if you want to check the string, it's jenniferslaw.org@gmail.com.
So, Mr. Holtzman, I'm going to ask you to revise the order to put her preferred mailing address and her preferred email address, and we'll include that as the place where further documents will be forwarded to her. As far as the statement that Dow Law Firm plans to maintain an expense interest in the claim but no fee interest, and as far as Ms. Connolly's concerns about the amount of the expenses, that's really beyond the purview of this court to order one way or another. So I'm gonna remove that line if you send me the order that includes that line, and I'm gonna let y'all find a way to resolve that dispute otherwise. But I am granting the motion for you to withdraw, but I'm not going to dictate the terms on which you withdraw in terms of whether you have an interest in the case in fees or expenses. That's kind of outside the realm of what we're doing here.
Are you able to ask them to turn over the documents I've been requesting for 6 months so that we can try to resolve that?
So again, your issues with your soon-to-be prior lawyers are issues that you're going to have to resolve with them, and the court isn't involved in that dispute at this point. So I will just say that I'm sure that Mr. Holtzman is aware of his professional obligations to you as your current and soon-to-be prior counsel. My understanding is that the file belongs to you as the client, and that the lawyer may keep a copy of the file at his own expense. That's just my understanding. I'm not making an order on that, and I'll let y'all work that out.
Yes, Your Honor, and we've provided Ms. Connolly with her file multiple times. I think what she's alluding to is the legal connection fees, and we've set her up and we've given her permission to talk to the legal connection and so forth.
All right.
But I haven't gotten a single document, as you are aware, not a single one that I requested.
All right. Well, I'm sorry I can't help y'all with that dispute. All I'm here on is the motion to withdraw, and it's granted. And do send us that revised order, Mr. Holtzman, and we'll get it signed and filed.
Can Can you comment on the court's preference? I don't know how you do things here in Texas, or as I asked, like, is it my determination on when we adjudicate this issue, or does the court have a preference if it's done before or after the trial?
I really can't advise you on that. I just know that at this point, that's not an issue that's before this court.
And so, Your Honor, I'm going to ask Jennifer for updated phone number, email address, and address. I'll add it on there, and I'll take off the expense lien line, and we'll. I mean, unilaterally, we can put a lien on our case, just for the expenses, but we're not taking a fee. It's just.
I understand that. I'll let y'all work that out. I hope you're able to do that. All right, thank you. Y'all are
That's
excused.
the last issue on the access to the public record, so that I'm able to litigate this case.
That's not anything that I can help you with. The district clerk's office is where documents are e-filed, and you may be able to speak with them about that, about how to get access to it. But that's, again, not something that the court's involved in.
Okay, and who do I speak to about, I seem to not be authorized to use the box, and I haven't been able to get that resolved.
Sonali, this is Michelle Williamson. I'm the court reporter. We have been experiencing box issues today. We just received an email from our IT department at Travis County. So it's not, I see that you likely received an invitation to box. There are 4 collaborators that never accepted the invitation. So it appears that you did have access possibly, but there's issues with box. So it's not that you're being deprived. It's just there's IT issues.
Well, did that go back a week? Because I got my first invitation last week, Thursday, and every time I click on the accept invite, I get an error code that says 403, your client does not have permission to get URL, whatever, from this server.
There also is information that was sent by Ms. Fatima called Guidelines on Electronic Exhibits sent by our court. And it explains everything you need to do if you have any issues with box. And that would be to contact court's help. And there's a phone number and an email address to do that.
Okay, I did try to call them. I've not had anyone answer, but I will, I guess, continue trying to call. Now that I'm not represented, is Fatima or Ms. Fatima allowed to answer administrative questions?
Well, so we have a central docket in Travis County. This case is not technically pending in front of us at this point. Once I sign this order, then my involvement in your case is over. But my staff is here to assist the court, and if she answered legal questions to all the people who have cases pending in Travis County, she would never be able to do her job. So there's limits on what she can do, and she can't give legal advice.
Well, I'm not looking for legal advice. I'm completely competent to handle my legal affairs, but there's things that I've made multiple attempts to resolve that people just don't know. And so I spent many hours on the phone last week. I don't even know how to find out who my case is assigned to. And I didn't know.
Your case is not assigned to anyone. And one of the documents that Ms. Fatima sent you should have explained how the central docket in Travis County works. We're on a central docket. Next time there's a hearing, you'll be assigned to a particular judge for that hearing. The fact that I'm assigned today just means I'm assigned today, and you may get 6 different judges for 6 different hearings, but that way you get heard really quickly. And so that's how the central docket works. And there is a set of local rules. One of the documents she sent you has a link to that.
And does it always come just 48 hours in advance? I guess that was my issue. I didn't know when it was coming, so I was getting nervous, and then I'm like waiting. I didn't know 48 hours.
So our cases are assigned on the Thursday or Friday before the week of the hearing. So in each time you have a hearing, you'll get a notice of which court on Thursday or Friday the week before, if you announce that on the case as required by the local rules. When you get to the point where you have a jury trial, you'll have a docket call and get assigned to a judge, usually about 10 days before the trial.
Okay. It seems like there's no way for me to find out that Thursday announcement who it's assigned to. I had to ask someone. They said that only lawyers could look it up. So,
There's a public website that anyone can look at that shows the docket. And if you just Google Travis County Civil District Court docket, you should be able to click on the date and time of your hearing by Thursday of the week before, and it should tell you who it's assigned to if it was announced.
okay.
All right.
Okay. So just to conclude, so Mr. Holtzman, I'll call you right after this, give you my contact information, and Ms. Holder, I will also, if you're available, I'd like to call you to set up a call just to kind of see where we're at going forward in this case.
Sounds good. And Michelle, I'll send you the order once I've got her updated address. Does that work?
Send it. Just reply all to the email that Ms. Fatima sent out.
Yes,
and
Your
send
Honor.
it that way. All right. Thank y'all. Y'all are
Thank you.
excused.
Thank you.
I don't see how this court has jurisdiction to do anything. There is no way, unless you can show me a case that specifically says that a trial court has jurisdiction to tell the appellate court that they have a bad appeal. I can't, I've never been asked to declare an interlocutory appeal improper. And I am not impressed from the pleadings that I read that I have that authority. So, Ms. Anahoro, although I have a great deal of interest in your case and I understand your position, and I would like to be able to help, I think that the Court of Appeals has to tell us whether or not the appeal is a valid one and not the trial court. I can't hear you at all now. No, no volume at all. We heard you faintly before, so whatever you did before was better than this.
Can you hear me now?
Yeah, faintly. So you may need to shout or something.
Okay.
I don't know.
Okay. Can you hear me now? Like this?
Now we can hear you.
Okay, so I'm just gonna scream. Okay, so in relation to the rule of where the defendant is using for the interlocutory appeal, they don't meet the requirements to do such. So one,
I don't disagree with you about that. You may be right about that, but I think the Court of Appeals has to decide that, and a trial court doesn't get to dictate to a Court of Appeals that the appeal is no good. It kind of turns the whole scheme on its head if trial courts start telling appellate courts what they can do and not do.
well, the basis of that section is that it triggers an automatic stay. So if you don't meet the requirement, then an automatic stay wouldn't be triggered. There is a,
And I think you need to file and I think you should, if you haven't already, file a motion in the appellate court
it's fine.
asking them to confirm there is no such stay, but I don't think I can tell them that.
Okay, Your Honor.
Generally, when there's an appeal, the issues are out of my hands, and I think even more so in this case. And if you are correct, then the Court of Appeals ought to take action and dismiss the appeal, and or tell you that the stay is not in effect.
Okay, Your Honor.
And while I appreciate why you're frustrated, and I understand that you're unhappy about the way it all came down, I just don't see how I have authority to do anything.
Okay.
You've had two different judges deal with this issue of the plea of jurisdiction, And I think you now need to get the Court of Appeals to weigh in on it. And I understand that's very frustrating from the perspective of a delay. And Mr. Burris, I'm very skeptical about how your clients have handled all of this. But until I have jurisdiction again, or until any trial court has jurisdiction again, I don't believe I can take any action.
Okay, thank you, Your Honor.
All right. Sorry, I can't help.
It's
We'll
not-
just make a docket note that the court declines to act unless or until the Court of Appeals lifts the stay or dismisses the appeal.
Thank you, Your
All
Honor.
right. Thank you.
Thank you, Your Honor.
Y'all are excused.